Good morning to everyone in Europe and good afternoon to everyone in China. Welcome to the EU SME Center webinar series. I'm Benoît Mizon and I'm Market Access Advisor at the EU SME Center, and it's a pleasure to have so many of you again on board for today's webinar. Just in order to make sure again that everyone is hearing us, I'd like to just make sure that you can actually hear us, so you can, for those of you that are not familiar with the panel, with your control panel, you've got a hand on the left-hand side. If you can hear us, just click on it and we'll see that everything's working well today. Okay, I see that most hands are going up, so I imagine that most of you are hearing us. I think most of you are familiar with the panel already, but just as a reminder, you've got a number of functions, and next to the raise your hand, you've got the questions panel. We'd like to invite you again to ask as many questions as you have in mind for this particular topic during this session. Again, as the number of participants is increasing, I'm not sure whether we'll manage to answer all questions during the webinar, but as during every webinar, what we'll do is that if there are any answers or questions we don't manage to answer, we'll get back to you at a separate time. And I'd like to invite you again to also refer to the website and our inquiry system to get back to us if you don't have any particular questions for this webinar, but as a follow-up maybe. As a quick reminder, the EU SME Center is an initiative funded by the European Union and fully financed by the European Union. We're here to helping European SMEs to establish and develop commercial activities in China by providing confidential information and advice, and that free of charge. We have an office in Beijing that is here to help you on several questions of 15 people. Typically questions we're answering are on business development, standards and conformity, legal aspects, as well as HR aspects. And we provide a number of different services in terms of publications in our knowledge base, case studies, guidelines, as well as a number of additional events like trainings and seminars, and increasingly, as you're familiar already, to our webinar platform. And today we're going to address for the first time an HR related question, so really on how to manage China's quintessential resource, its people. And we'll actually have a series of different HR related seminars, and today's webinar will really touch on overcoming the legal challenges. For that, we have invited Johnny Choi, which is an associate at Simons & Simons. And Johnny, I'd like to pass on to you to maybe quickly introduce yourself and to start today's webinar. Thank you.
Hello everyone, my name is Johnny Choi. I'm an associate at Simons & Simons Beijing office. I've been working on PRC employment law since 2005, advising multinational clients on various employment issues, including hiring, termination, enforcement of company policies, and employment due diligence, and other things like downsizing, wage and hour laws, and non-compete restrictions, and all these different issues. It's an exciting time because PRC employment law is undergoing various reforms, and it's a pleasure to be presenting at this webinar with Benoît. So in today's webinar, we are going to talk about how to overcome legal challenges in hiring employees. So as I mentioned, there has been a number of recent developments on labor laws in China regarding how to employ people, whether it's local employee or expatriates. So I talk about how to employ employees in compliance with PRC law, and also how to employ expatriates, and also when there's a dispute with employees, how to resolve disputes, especially given the rigid rules around terminating employment in China.
Thank you. I think one thing which would be useful for us is actually first to gauge our audience on their knowledge of HR aspects in China. As mentioned, this is really one of the first webinar we're doing on HR. It's interesting for us to get the feedback, but also to try to see actually what are the challenges which companies expect here. We feel that very often there is a gap between the knowledge, the reality in China, and actually the knowledge of the HR developments in Europe. So I hope that we can overcome that, but let's see actually in practice whether that's the case. So I'm going to launch for you the first poll, and which is really about what are the key HR challenges which you may face in China, and I think that you should have the different options coming up. So we've indicated as possible answer A, shortage of qualified workers, B, high turnover and low retention, C, rising labor costs, D, all of these issues, or E, there are no challenges because China has got such large talent pools to draw on at very competitive prices. So I'm seeing all the answers coming in, and I'm going to share the results with you, and there is actually no surprises here. 70% of you are answering all of the above, and in fact, from different studies and surveys, indeed, these three different issues, shortage of qualified workers, the turnover and poor retention, as well as the labor costs, which are increasing on a very regular basis here constantly. Really, these are really the main challenges which we are hearing back from SMEs and companies altogether here in China. And I think maybe this webinar today will answer a number of these aspects to try to actually facilitate maybe a number of processes. But I think altogether these different issues will be addressed in the different webinars, because companies have actually to become increasingly more creative in the way that they're actually attracting and retaining their staff, and questions of wages and packages is really only the start of the story. I don't know if you have any other elements on that, Johnny, but otherwise what I can do is to launch the second poll to really see what is the feedback from the companies on specific legal issues. Okay. So I'm launching with you now the second poll, which is really trying to see specifically on the legal aspects, what are the employment law issues that concern you most. So you've got the different answers which should be coming up on your screens right now. A, how to hire employees legally. B, understanding mandatory employment terms and benefits. C, hiring foreign employees. And D, how to terminate employment lawfully. The answers are coming in, and actually what I'll do is to let Johnny commenting on them. We've got quite a large number of companies which indicate the mandatory, understanding the mandatory employment terms, as well as the questions of how to terminate employment lawfully. I'm actually sharing with you the result now, and Johnny, if you could, I mean, you're going to be speaking about all these aspects, but if you could share already your first ideas on whether these were the answers you were expecting.
Yeah, I mean, the answers are, as expected. The mandatory employment terms and conditions. They are, a very important issue that faces multinational companies. And, also termination of employment is a very, has always been one of the key issues facing companies in China because of the very rigid rules and requirements regarding termination of employment. And, also there's some response on the hiring employees and foreign employees. They're also pretty common issues that arise when when a company operates in China.
Okay, but these are really what the subject of the matter of today. So with this, I'd just like to hide the poll results, and then if we can start now with analyzing a little bit in detail the challenges and how to overcome them. So the floor is yours, Johnny.
Okay, so hiring employees in China, there are a number of ways an employer can hire a local employee in the PRC. There's direct hire, which means the company signs a contract directly with an employee, with the employee signing the contract with the local subsidiary. There's also indirect hire. Indirect hire includes labor dispatch and outsourcing. Labor dispatch is commonly used in like representative offices, and especially it's not uncommon for foreign companies coming into China to engage a labor dispatch agency like FESCO, CIC, or China Star, using them to hire the employees. This is now subject to certain reforms in the PRC legislation, which trying to limit the scope of labor dispatch, and at the same time, now it's more common. Companies are considering the other option of indirect hiring, which is outsourcing, but outsourcing also has its limitations. For example, outsourcing could be outsourcing actually means that you don't directly hire the employee, but you use another company to do this function. But the risk of that is that it could be viewed as labor dispatch, and right now the new legislation, which is going to be effective in July 2013, that amendment to the labor contract law will limit the types of post-job functions that you could hire employees indirectly to temporary, auxiliary, or substitute jobs, and then of course you need also to treat employees equally, whether they're direct or indirect. So companies are now thinking about if they are having labor dispatch arrangements that they're now thinking about transferring people to direct hire. Offering employment, when it's common in Western jurisdictions, especially to use offer letter to offer employees a day job. This is not a requirement in the PRC, and the offer letter is not generally viewed as a binding document unless it is expressly incorporated into the employment contract, and also a Chinese version is used. There are different types of employment contracts. Employment contracts can be fixed term, which is quite common in the PRC. It could also be open term, or it could be specific for completion of a specific project. The PRC law doesn't recognize the concept of independent contractors, so that there's no easy way around trying to hire someone, but avoiding the employment law protections that are offered under PRC law. So it's mandatory in the PRC to have a written employment contract entered into with a local employee, if you don't enter into a written contract with an employee, the penalty is that you have to pay double salary from after the first month of the employee commencing employment. So if you don't enter into a written employment contract within 1 month of the employee's commencing employment, you have to pay double wages according to PRC law. Yeah, that's one of the key things that you have to do when an employee joins, unless you already incorporate the terms of an employment contract in the offer letter. And the employment contract usually needs to be in Chinese for various reasons. Some of the local regulations require a Chinese employment contract, and also if you don't have a Chinese employment contract, employees can very easily challenge the terms on the basis that there was a different understanding or it was interpreted differently. And of course, arbitration tribunals often will rule in favor of employees' understanding. It's difficult to impose unilateral changes to an employment contract. Drafting the employment contract needs to be something that considered carefully at the start. A contract, as best practice, employment contract must specify the name of the employers and the legal representative of the employer and the address of the employer. In terms of the employee, needs to contain information like the employee's name, address, resident ID card number, the term of the contract, the job description, place of work, working hours, leave, remuneration, things like that. And also the contract, we would also recommend specifying in the contract that the employee would adhere to workplace rules, include some data protection clauses. There's been a new data privacy guideline that was just introduced effective February 1st, which, although it's a guideline, it's recommended to follow the guideline for various reasons, including because it might be prelude to new data protection law that might come up, and also it might, the compliance of that would be favorable to protect the company in case of any, any civil claims on breach of data privacy. Also, other binding agreements such as confidentiality, IP assignment, non-competition agreements should be included with the employment contract. The PRC law also specifies the probationary period with an employee. It's the maximum length of a probationary period is linked to the contract term. So it varies from 1 month to 6 months, the probationary period, depending on the contract term. It is permissible to agree in the contract that during the probationary period, the salary is a lower level of salary will be paid than after the passing probation period. And also, the probationary period cannot be, extended beyond the maximum, and it is limited to 1 probationary period per employee. And then there's social insurance in the PRC. It's mandatory to include a provision regarding social insurance, and it's also mandatory to participate in social insurance in the PRC. And there are 5 insurance schemes: pension, medical, work-related injury, unemployment, and maternity insurance. And on top of that, there's also housing fund, which is also mandatory for local employees. These schemes add up. Actually, it represents quite a high cost. it's for someone who, for example, in Beijing, if the employee earns something like less than 14,000 RMB, which is I don't know 10,000 euros a month, then
it's a bit less than that.
Less than that.
The exchange rate is not that low yet. It's still about maybe 1,800 euros.
Okay. For someone like that earning that amount, then the portion the company has to pay for the social insurance is in total, including housing fund scheme, is like 42% additional cost. But if someone earns higher, then it's capped at that amount. And also the amount of contribution depends on the location. So in cities like Beijing, Shanghai, where the average income is higher, then the contribution amount required would also be higher compared with other more inland cities.
I just have a quick question on this information. Is this normally information which is easily available online, for instance? How would you typically go about finding these rates?
It's actually not so easy to find from an official source because it's in Chinese, most of the government websites. But you could try and if you need further information, you could search for publications from companies and third-party providers information on PRC, either HR issues or just doing business in China kind of publications.
Okay.
Yeah. There was a new law which was introduced in 2011 and then subsequently some implementing measures on foreigners' participation in social insurance. Prior to 2011, foreigners weren't required to actually participate in the social insurance scheme, and so this new law required all foreigners to also participate, which means also increase the cost of employment for foreign companies in China who hire foreigners. The prerequisite is, of course, the foreigner has to have already obtained a work permit to work in China, and then once the work permit is obtained, the company needs to register the foreigner for social insurance within 1 month. I'll talk more about the hiring foreigners later, but currently most cities have implemented this law except in Shanghai. In Shanghai still hasn't really implemented, and the local labor authorities there, they don't regard that as mandatory for foreigners to participate in social insurance schemes. Another exception is possibly for Hong Kong, Macau, and Taiwan residents. In case you are hiring someone who has those residency status to work in China, then it's not right now. It's not. There's still no express requirement for them to participate because they are not, strictly speaking, they're not regarded as a foreigner. And also, certain countries which signed bilateral treaties with China regarding social insurance, like Germany and South Korea, and also I think the UK is going to sign one soon regarding social insurance. If they have already signed a treaty, then certain items of this insurance scheme can be exempted if they already contribute it in their home country.
So just to clarify on this one, it's only then if they're already contributing to it back home. It wouldn't be just exempting them from the system here.
Yes, that's correct.
Okay, thank you.
China also has a number of different types of leave and holidays that the law grants to employees. And these include marriage leave, maternity leave, nursing period, nursing breaks, paternity leave, sick leave, medical treatment period, annual leave, and others. For marriage leave, it actually depends on the locality. The entitlement will vary. For example, in Beijing, someone usually would get 10 days of marriage leave, unless, or 10 calendar days, which is like a week, unless the employee marries very early, like under 24 or 23 years old, in which case it's 3 days. In other places, it could be higher than that. And in terms of maternity leave, it's usually right now it's around 3 months of standard maternity leave, and then usually it would be go to 4 months if the child was born when the mother is older than 24 or 25 years old. So normally someone, unless again they fell pregnant early, then it would be like 4 months, and then there would be additional maternity leave in special circumstances like multiple child, like a twin or triplet, or complications in child delivery. I'll also elaborate on this later during the termination section on terminating employment. There are quite a few protections against termination for female employees who are pregnant, or who are enjoying their maternity leave, or during what's called the nursing period. The nursing period means the child is born from the time the child is born to 1 year old. So during this period, even after the female employee came back from work, the employee is protected from termination of employment, unless there are gross misconduct and very serious circumstances. Paternity leave is not a national, not granted under national law, but some of the local rules and regulations specify paternity leave. For example, in Shanghai, the paternity leave is 3 days. But in other cities, it's different. For example, in Beijing, male employee could enjoy up to 1 month, but it's in exchange for the female employee not taking the maternity leave. In practice, very few would enjoy paternity leave in Beijing. In terms of sick leave and medical treatment period, the PRC law grants some kind of medical treatment period to employees, and that period could, depending on the seniority of the employee, it could be up to 48 months, or 24 months of medical treatment period. And during that period, the employee is protected also from termination of employment, unless in gross misconduct or other serious circumstances. The medical treatment period means that the employee is protected from termination, but where the employee is away from work for sick leave, the payment of the employee's salary also varies according to the location. So you need to check local regulations on this type of leave issues. For annual leave, employees are entitled to 5 to 15 days, depending also on their period of service. And the period of service is counted. It's not just with the current employer, but also with previous employers. So if someone, for example, the period of service with all employers is less than 10 years, then it would be the employee would be entitled to 5 days. But for someone 10 years to 20 years, the employee would be entitled to 10 days of leave for someone who is over 20 years service with all past employers and current employer, then the employee will be entitled to 15 days. There's also some regulation regarding home leave and bereavement leave. In practice, it's common to grant bereavement leave, even though the bereavement leave comes from regulations that apply to state-owned enterprise only. But it's not common to grant home leave, or it's also called family leave to employees anymore. Although the regulation is still not being repealed yet. So also one thing to note is that in China there are 11 statutory holidays. But during these holiday periods, the public holiday, as in the weekends, usually Saturday and Sunday, they would be moved around the statutory holiday, so they form a long break. But the employee will forego the weekend, so they have to work during the weekend.
Actually, why a lot of our friends and family members back home are surprised to see us working so many weekends. But I think it's useful to also mention that this is normally done also to make sure that people have sufficient time to actually do some traveling and go back to their hometown. I have a quick question on this one also, Johnny, because I mean we've seen through all these elements and some of the other ones and some of the future aspects that you will be covering that there's quite a bit of disparity between different regions and provinces and cities in China. What do you think is generally the trend? Is it there more and more harmonization on the national level, or is there actually more decentralization to actually let the local authorities decide on that? Do you see it going more one direction or the other?
There's going to be more nationalization. Certainly the government at the national level is pushing for a number of reforms, like the one I mentioned at the beginning of the webinar, which is the amendment to the labor contract law, and also there are a few that have recently came out, including for non-compete period restrictions. They have been trying to push for uniformity in terms of those kind of and also what I also just mentioned is the social insurance law. So they're pushing for more uniformity and the same kind of rules and regulations. But at the same time, of course, while the national level government is pushing for more centralization, there's always local interpretation and local practices. There's always going to be variation. Also, for example, the social insurance law that I just mentioned, even though at the national level they're pushing for all foreigners to participate, but then in Shanghai, in practice, they're still not trying to implement or enforce that.
Mm-hmm. Okay, interesting.
I'm also moving on to talk about some of the protection or employment promotion regulations. There are rules and laws and regulations regarding anti-discrimination in employment and protection against sexual harassment and things like that in PRC. But they are by no means as developed or as sophisticated as in the Western countries. They're usually just general prohibitions against discrimination. For example, in the employment promotion law, there is a prohibition against discrimination based on ethnicity, disability, race, sex or religion, etc. Also other regulations that prohibit discrimination against rural migrant workers and infectious disease carriers. These laws and regulations, they are kind of tend to be aspirational, more in nature. In practice, the enforcement is not not too strong. And also, partly because there's no very developed rules and regulations on, what's the definition of discrimination and other things like specific penalties against, non-compliance with these laws and regulations. So the enforcement is not very strong. In the law for protection of women's rights, there's prohibition against sexual harassment against women. And then in 2012, there was a regulation on special labor protection to female employees. That regulation tries to enhance protection to female employees, and the employer imposed an obligation on employers to prevent sexual harassment. But then again, it doesn't specify what's the penalty for non-compliance, and usually that would, that would only, become a risk at the level of the employee, bringing a civil claim, and how an employee might try and enforce that against the employer, it still remains to be seen.
Okay, that's. I think now we're actually moving to one of the questions that is actually quite important to our SMEs, which is mostly related to cost actually. So again, here I want to try to gauge our audience by launching the next poll on the question of China's national minimum wage, and I'm sharing the poll with you just now. And so basically, do you think that which statement from the ones that you can see is most accurate? That A, the national minimum wage is 1,288 RMB per month. B, 488 RMB per month. C, that there is the minimum national wage is actually increasing by more than 10% every year in many parts of China, or that B, actually there is no minimum wage at the national level, and because it is set by local authorities. As I'm closing and sharing the poll results with you, clearly most of you have the right answer. There is indeed no minimum wage in China. This is something which is set by the local authorities. As we were talking about, there are quite a few things on touching on labor contract law and on HR aspects which are set at the local level. I think that from recent figures I was checking, I think maybe minimum wage in Shenzhen, for example, is something around 1,500 renminbi, but it can be as low as maybe 600 renminbi in some other places. So I think there is quite a bit of variation here. In fact, in different localities again.
Right. Yes. There's the minimum wage level is not set at the national government, so it depends on local government, and it varies depending on the income level of the different localities. So moving on to wages and working hours, the PRC law provides 3 types of working hours system, and one is the standard, and there are 2 special working hour system. For standard working hour system, it's 8 hours per day and 40 hours per week. Special working hour system includes 2 types of working hour system. One is flexible, the other one is comprehensive. Flexible means working hours would vary depending on business needs, and in general terms, the employee won't be entitled to overtime wages. Comprehensive means the working hours is averaged out, and if you could exceed the mandatory 8-hour or 40-hour work week based on seasonal considerations. So the Labor Bureau approval is normally required if you want to implement special working hours system to avoid the payment of overtime wages. But there are exceptions, local exceptions, for example, in Beijing and Shenzhen. There is currently a draft rule on special working hours published in 2012, and that's aimed at, again, eliminating regional differences and local discretion. So it's possible that the exemptions in Beijing and some Shenzhen could be, eliminated, so that the approval is still required in those cities for senior management personnel who needs to implement this special working hour system. Also, there's going to be new category of employees eligible, for R&D companies, could be relevant. People who engage in innovative types of work, or other types of technical types of. But that's still a draft rule. Still going to be published. So we need to wait and see what's the final draft going to look like. We have a case study, it's regarding overtime wage claim by an employee. The employee has worked for the company for 10 years, and the employee wants to claim overtime wages from the company. He said that there was overtime approval policies, but they were never given in practice, and everybody just works more than standard business hours. And there is evidence was submitted showing that he worked overtime. The court interestingly rejected the employee's claim. That's because the court said that overtime wages is only payable if the overtime work is arranged by an employer or requested by an employee and approved by an employer. Although the employee's evidence shows that there were some things showing that he was working at after hours and things like that, the court said it doesn't show that the company specifically requested the employee or actively arranged the employee to work. That there was overtime approval policies that wasn't the employee didn't obtain approval. The court decision here is interesting, especially because it's a decision in Shanghai. Usually Shanghai is seen as more employer-friendly. It remains to be seen whether other courts and will take the same view. In China doesn't have a precedent system, so they could take different decisions. So the meaning of this case is that if you have an overtime approval policy, you could potentially manage the overtime wage claims from employees who are under the standard working hour system. So we have just talked about how a usually normal local employee can be hired in the PLC, and we are moving on to hiring expatriates and foreigners and how to structure their employment. For hiring expatriates, there are you need to first satisfy the visa and entry requirements. The nationality and permanent residency status matters. I previously referred to Taiwan, Macau, and Hong Kong residents. If they are one of those types of residents, then it's different. They don't need to obtain a visa, but they still need to obtain a work permit to actually work in China. And in June 2012, there was a new law passed regarding entry and exit of foreigners in China, and it's going to be more strict enforcement of foreigners coming to work in China. Whereas previously it wasn't really strictly enforced, that the requirements that the foreigners should be working in China only in those positions where you can't find local employment. Now it looks like the government wants to impose more restrictions on that. and there's going to be a catalog of different types of jobs that are available for foreigners to be employed in China. And structuring the employment for expatriates. For expatriates, there are it's an exception because there are different ways in which expatriates can be employed. There's secondment. There's also direct hiring and also dual contract. Secondment means the expatriate is hired overseas, and then the documentation is overseas and governed by foreign law. The employee is just seconded to work in China. Direct employment means the foreigner works in China and signs a contract with the local entity. Dual contract means both a combination. So there's going to be overseas documentation. There's going to be local documentation as well. The advantage with secondment is that the employment is governed by foreign law, and which could be desirable if the home country's employment law is less stringent than PRC, but it may create what is called a permanent establishment for the foreign company in China, and this could mean some adverse tax consequences. So that needs to be carefully considered. Direct employment is, on the other hand, it avoids the tax issue, but then the foreigner will be totally, fully subject to PRC legal protections like a local employee. And then dual contract is a combination. You could try and structure the employment so that the overseas employment still kind of prevail, but then you're trying to avoid the tax issue at the same time. The visa requirements, already touched upon that just then. Basically, you need a work visa if you want to be employed in China. You could also obtain a business visa, but that, strictly speaking, is not for employment. It's for business travel. But in the past, it's been not uncommon that foreigners actually come on visa or business visas, but actually are working. It remains to be seen whether the new law on entry and exit will make this more difficult. We have seen some instances where foreigners are now beginning to experience some difficulties for entering into China with business visas, multiple entry, and trying to work in China. Moving on to dispute resolution and dismissal of employees. Is a common during the poll is one of the most common issues that you have indicated. Termination is there are only very limited grounds to terminate employment in China, it's limited to things like non-performance or gross misconduct, and practically the restrictions means that you have to collect a lot of evidence, and you need to for multinational companies, you need to keep paper trail of how employees become not performing up to standards. So it's all very burdensome and costly sometimes for employees. So the most common way for employees to be depart from the company is still to negotiate with the employee, unless the employee is on a fixed-term contract, which is why I mentioned at the beginning, fixed-term contract is not it's quite common in the PRC. It's for this reason, because an employee could be let go very easily at the end of the term. If an employee has an open term, then you have to rely on one of the grounds under PRC law. For the termination of employment, it's always that there's a list that I have provided regarding the various grounds for termination. There's where you need to provide notice, and then there's grounds where you can just terminate immediately with no severance, and they are the limited grounds that I've listed. For termination, generally, because I mentioned that there are strict limitations on how to terminate, it's usually common to negotiate. And for negotiating employment, the companies would normally consider what's the alternative to not negotiating, from the best alternative to the worst alternative. For the worst alternative, usually it would be the employee suing the company, and then there are two potential claims. One is the less serious, which is a double statutory severance. Statutory severance pay in PRC, it's calculated based on 1 month per year of service, but it's also capped at 3 times the local average monthly wage, which is, for example, in Beijing, it's 14,000 RMB, again, around 18,000 euros. For the other more serious consequence is reinstatement to the original position. And, but then again, the law also says that reinstatements will not be ordered if it's impossible. So the employer needs to consider when terminating employment and then negotiating with employee for the exit, what's the risk of the worst alternative. Sometimes, for example, if it's a senior management personnel, for example, the legal rep or the chief rep of the company in China, then you could make a case that it's going to be impossible to reinstate the employee, because once you change the company records with the company registration authorities, then the person is gone. You can't have, if you replace the person, you can't have another one reinstated back to the same position. There are other circumstances that you can consider here. And usually when you have this kind of situation where you need to terminate employment, then you end up negotiating and determining an offer of compensation for the employee to leave the company. So just quickly on the process for arbitration, it's a mandatory first step. You have to go through arbitration first before you go to the court. It's free for the employee to initiate a claim. They don't have to pay anything. But there's a limitation of 1 year, generally after the event, that the employee can make a claim. If the event has passed for more than 1 year, the employee is barred from making a claim. And also, the Labor Arbitration Commission usually wants to move employees to direct the parties to go through mediation and negotiate settlement before the hearing. After the arbitration award is given, then you could also appeal to the court. There are two-tier appeal procedures. In summary, what you might want to take away from this webinar is that in terms of understanding the terms and conditions, mandatory terms and conditions PRC, you have to sign a written contract within 1 month of employment of the employee, and the contract should be in Chinese. You should include all the mandatory terms and other key provisions. You should prepare an employee handbook and workplace rules, which is very important in China because of the limited grounds to discipline and terminate employees. In case you need to terminate someone for misconduct, you need to rely on the employee handbook. And also you should include provisions on overtime, approval and workplace discipline in the employee handbook. If you are hiring an expatriate, consider what kind of hiring arrangement, like secondment, dual contract, or direct hire. If you are hiring local employees, then use direct hire where possible and avoid the labor dispatch agency, unless you could use them for just payroll administration, but you avoid them for hiring, like a dispatchment of employee. When terminating employment, consider the best and worst alternatives to the negotiated settlement, like the risk of reinstatement and how much it would be to pay double statutory severance.
Thank you, Johnny. That's really, actually, we've covered quite a lot of grounds here, and we're running a little bit out of time, but it's really been quite interesting, and I'd like to still take a few minutes for Q&A, even though we're running a bit out of time, and I hope that the participants can bear with us a little bit longer here. The first question, which is coming out of a number of questions which have been asked, actually, is really, I mean, we've seen the complexity of the system and the variations. It's something which a lot of the SMEs which are setting up a WUFI or a rep office here in China will have difficulties to navigate themselves, especially as this is also changing on quite a regular basis, in fact. So it's really difficult to, I mean, this is your specialization, but is it actually really possible to do it on your own as an SME, for instance, if you're setting up here an office of 5 people? Is this something that is actually even possible to do on your own, or do you really rely on external service providers to do that?
You could rely on, there are external service providers. As I mentioned, that's one of the reasons why there was these types of labor dispatch agencies existed. But because now the government is trying to limit the use of labor dispatch agencies, then then you can't hire employees through these agencies. You have to directly hire them and sign a contract with them. But then those agencies still provide HR administration support services. So, for example, social insurance, you could use them to assist you and make the social insurance contributions and housing fund contributions. They could assist you, with tax, individual income tax withholdings and other types of issues. They could also help you, advise you on, if you need some, documentation with employees, you could also have them assist.
So it's some sort of transformation. I mean, it's not dispatching as it exists now, but it's more or less outsourcing to these same so-called dispatches of FESCO and CCIC and STAR,
yes.
Or other agencies, and I suppose there are quite a number of doing that. There is a question which is stemming directly out of that, because the only possibility for rep offices to employ in China today is through these dispatch agencies. Are they likely to be affected through these changes in law, or is there going to be a status quo?
Rep offices are a special case in this new law. Because rep offices cannot hire other than through these labor dispatch agencies. So the new restrictions against using the labor dispatch agencies, they won't apply to rep offices.
Okay, thank you. Moving on to the next questions immediately. We've mentioned it several times about contracts being in Chinese. Is that actually a legal requirement? Does it mean that if I prepare a contract in English, it's void?
That is at least it's a legal requirement in Shanghai. It was a legal requirement some years ago, but that legislation has been repealed. But it's not because of that reason of that provision in the law. And in practice, if you ask most of the labor bureaus in the PRC, they would say that labor contract is required to be in Chinese. If you are not in a location like Shanghai, then if you only have an English contract, it doesn't necessarily mean that you have an invalid contract, and there is a risk that you will might have to pay the double salary because of not entering the written contract. But you could try and argue the position that an English contract is still a written contract because there's no express provision right now in the law, except in some location like Shanghai, which requires Chinese contract. So it doesn't mean it's invalid, but necessarily. But then, if you don't have a Chinese contract, you would be in very disadvantageous positions in many situations. Like the employee could challenge. We have seen cases where even the senior executives who understand English, a local employee, they would challenge that they either didn't understand the provision or they had a different interpretation, and it's very difficult or impossible to argue that the company's interpretation is the one that should be followed. And usually the labor tribunal actually follows the employee's interpretation.
Okay, thank you. That's quite useful. And then maybe just to close, I'll take a couple or consolidate maybe a couple of questions that have come specifically on maternity leaves. And the question reads that is late maternity leave, so the 30 extra days, only applicable to the birth of the first child? And the other question on maternity leave is what actually happens when, in the case of a second child, which is not in compliance with one-child policy in a number of cases? How does a company have to treat this in terms of well, in practice, really? Okay. This is something which is a China-specific question, but useful to also have your views on that.
Yeah. So for someone who has a late maternity leave, but it's not the first childbirth, the law doesn't grant that additional maternity leave, because the additional maternity leave for someone who has late childbirth, that was granted under legislation regarding the control of a one-child policy and the childbirth controls implemented by the PRC government. So the additional maternity leave doesn't apply if it's not the first child. In terms of the where it's not the first child, and what in practice happens with maternity leave is that the maternity leave is still granted, but then during the maternity leave, the employee won't be entitled to the benefits. For example, the maternity insurance that would pay for the costs and the salary of the employee, and depending on the company internal policies, then the company, if it fits in with the company's policy, it could also introduce in the employee handbook to say that during the not for first child but second or third or so on the childbirth, then the employee won't be entitled to maternity leave benefits during those childbirth, but they should still be entitled to the leave, but not to any benefits during.
Thank you, Johnny. I think we'll leave it to here for today, because even though we've got quite a number of other questions, we're a little bit beyond schedule. But thanks for sharing your experience and your views. We see that it's quite a complex system. It's one which is probably difficult to follow, and especially as an SME, useful to, and as we mentioned in many of the other webinars, useful to actually rely on external partners and finding the right partner to help you with these kind of questions, to make your life as a company, as an SME, easier on this market. So I would like also to thank today's attendants for being with us today, for your questions. If we didn't manage to take all your questions and to answer to all of them, we'll try to get back to you separately. But I'd like also to remind you about the possibility of logging into our website and sending through all your requests directly through the Ask the Expert function. Fine, last but not least, I'd like to continue inviting you to logging into our website, registering if that's not the case already, so that you can actually access to documents in this and other areas. Actually, I'd like to remind you about a number of reports and guidelines and case studies also specifically, as well as an electronic learning modules on questions of human resource management on the website. And then, of course, to continue following our webinars in the next coming weeks, we'll be talking about organic foods. Next week, we'll be talking about advantages, disadvantages of setting up a WOFI and a rep office the week after, and we'll be following with quite a number after that on a week-to-week basis. So again, thanks for the presentation of Johnny. Thanks for your attendance, and I would like to remind you also, don't forget about the evaluation going through just after the webinar. This is useful for us to constantly continue to improve the webinar platform, and also to continue to identify topics which are of interest to you. So thank you again, and see you next time at the EU SME Center webinar series. Bye for now.